Welcome everybody to today's webinar. My name's Chris Galvin. I'm the Head of Communications and Outreach at the International Code of Conduct Association, based here in Geneva in Switzerland. I just want to welcome you all, whatever time of day it is where you are. We have a lot of people registered from over 50 countries, so it's great to see that there is a lot of interest in this subject today. The subject of today's webinar is reducing human rights risk in your private security supply chain. And as the title of the event suggests, the focus of this webinar really is on clients of private security companies. We have a great panel to take us through proceedings for today. I'm not going to introduce everybody now. We'll take each in turn. The first person I do want to introduce is Jamie Williamson, who is the Executive Director of the International Code of Conduct Association, ICoCA. And Jamie is going to take us through, give us an overview of ICoCA, the mechanism, and really take us through how ICoCA can help in human rights due diligence across the private security supply chain. So Jamie, over to you. Jamie, you're on mute.
There we go. It's like a year of this and we're feel rusty all the time. But again, thank you very much, Chris, for the introduction. And welcome everyone to this webinar, where I think we'll be looking specifically at the question of human rights due diligence and at some level how and where ICoCA fits into this sort of discussion and the added value of the association in that regard on these issues of human rights due diligence, of raising standards within the security industry, and a little bit where we hope to go over the next few years in this particular field. As Chris, you mentioned, not everyone on this particular webinar is familiar with the association, so I'll take a few minutes just to give the background as to where the association comes from and how it was created. It's a multi-stakeholder organization, which was established in 2013 as a governance structure, as a mechanism to oversee the implementation of the first, and I think only of its kind, international code of conduct for private security providers. The code of conduct focuses predominantly on human rights and humanitarian law sort of obligations, in particular for private security companies as the main actors to whom or for whom this code of conduct is addressed. It's multi-stakeholder. It brings together security companies, 100 or so security companies at this stage, a number of governments, 7, civil society organizations, I think we range around 40 from different parts of the world, as well as a range of observers, everything from academics and think tanks through to major clients, multinationals, and certification bodies. The work of the association, when it was established in 2013, was very much focused around 2 sets of, let's say, international documents which had been developed. One of those was the so-called Montreux document, which was very much focused on questions related to the actions of private contractors, military as well as security, in armed conflict situations. And that document was simply a restatement of pre-existing international law with regard to the operations and oversight of those actors in armed conflict situations. And the document was particularly addressed to government actors. The second, I think, most pertinent one for the purposes of our discussions today were the UN Guiding Principles on Business and Human Rights. And I think they mark their 10th anniversary this year as well. And those principles very much focused around the protect, prevent, and remedy kind of pillars, looked at, how do we improve the respect of human rights by governments, by businesses in a variety of contexts. And there's a particular, I think, focus in that second section of the UN Guiding Principles on the questions of corporate responsibility, on the actions of businesses to ensure that businesses respect human rights and that businesses put in place the necessary mechanisms to ensure that they mitigate, address, remedy any human rights issues that they may have in their supply chain. And there's a number of principles which try to detail the kind of foundations and so the operational principles that try to detail what businesses need to do. and ensuring that you have an effective human rights impact assessment and a human rights due diligence process is at the core of many of these principles. That was about 10 or so years ago. Fast forward to where we stand today, and for those of you in this particular world and many of you on this webinar, you'll see that the debate has evolved substantially, and we're seeing a greater accent on the question of mandatory human rights due diligence. Previously, documents referred to should as verging on being voluntary in terms of processes. But now we're seeing the narrative evolve quite substantially, where governments, regulators, and others are trying to push for a much more rigorous, robust, and in particular, a mandatory human rights due diligence for governments and businesses in particular in different parts of the world. And that mandatory human rights due diligence has been gaining traction, especially in this part of the world. So we have, of course, from 2017, the Loi sur la Vigilance in France. We've seen developments in Germany recently, EU parliamentary resolution of March of about 2-3 weeks ago, which spoke about sort of mandatory human rights due diligence, which spoke about ensuring that this wasn't a tick the box exercise, and which would apply to multinational companies operating inside Europe, but also having operations outside Europe. We've seen developments here in Switzerland following a referendum last year with regard to ensuring that there's some level of responsibility for multinational corporations operating in Switzerland and with operations out of Switzerland. And importantly, these moves have also brought a focus on not simply the specific entities and their human rights obligations, the business entities, but have also put the accent on the supply chain, on the value chain of corporations, ensuring that all corporations put in place the necessary human rights due diligence requirements throughout their supply chain. And that would include supply chains where you have an element of security provision, where private security is hired. So where multinationals and other corporations and other clients use security companies, they would now be expected, and should have been doing so previously, but now more so given the latest developments at the regulatory level here, put in place the mechanisms and the processes to make sure that the security providers and suppliers that they have as part of the supply chain fulfill those human rights requirements, that any risks and mitigation elements can be taken into account to ensure that there are no human rights abuses committed by the security providers. So we're seeing that move towards the mandatory and the prevention side. But we have also been seeing a slight gravitation towards the kind of corporates, the legal responsibility of multinationals. And we don't have time in this webinar to go through all the latest cases, but if we just look at a couple of decisions coming out of the UK and the Dutch courts linked to Shell, you can see there's a growing focus on the responsibilities of parent companies and of actions being brought by groups against the parent companies for the actions of their subsidiaries. And that potentially could involve security components. And that the courts are prepared to look at procedures, policies, oversight and management with regards to potential liability or shortcomings when it came to human rights due diligence being met by those corporations. So where does the association fit in all of this? Quite simply, the association works with security providers to ensure that they meet their requirements under the code. The requirements of the code are human rights driven. So in many ways, what the association is doing is ensuring that security providers fulfill their human rights due diligence. But on top of that, as we look up the supply chain, that clients, those that use and hire the services of security providers, themselves have assurance that there's a level of human rights due diligence being carried out already within their supply chain, vis-a-vis the security companies that they may be hiring or using as part of their activities in different parts of the world. So the association then works with the security providers, raises their standards, and I think the direct effect of that is we're working up the supply chain vis-a-vis the clients to help them with their human rights due diligence with regards to the security piece. I'll pause here, Chris, so my introductory comments, and hand it over back to you. Thank you.
Thanks, Jamie. I'm just wondering whether you might want to go into a little more detail in terms of the core functions, for example, the monitoring that we conduct, the certification program, etc.
Definitely. Thank you, Chris. So core functions, there are three main core functions for the association, and they should be seen as sort of working together, not as standalone functions. There's of course the monitoring, the evaluation, the verification, as we call it, whereby the association works with its member companies and affiliates to oversee how they're applying the code and implement the code throughout their operations on a regular basis. So we have an annual verification process that every single company has to fulfill. Those that fail to meet their requirements under company self-assessment can be sanctioned by being withdrawn from the association. We have in-country monitoring assessments and field missions carried out by the association, where we will meet with security companies, have confidential dialogue with their guards, trainers, and management, and come up with recommendations on any particular issues for improvement or any potential compliance issues. We'll also interact with their clients and local communities and civil society organizations in country. And we also have a network built in particular through our civil society organizations to add to that monitoring support for the association, to continually evaluate how security companies are operating and to bring a kind of positive capacity building piece as well to our membership. Linked to that, there's a process, the sort of gold standard drive that we have as well. Ideally, we would like to see all of our security companies become ICoCA certified. And that's a two-step process, effectively, where first, the security companies need to become certified to industry recognized standards that the association has recognized, stemming from the ISO world in particular. There's an ISO 18788, an ISO 28007, and a PSC1. And so we look to certification being issued by accredited certification bodies in a number of contexts, and by certification bodies accredited to ISO 17021 in other contexts, to give us assurance that those companies meet the technical requirements for the management systems process. And then we go through an additional review of those companies' certification elements to determine whether or not they can be awarded ICoCA certification. And then there's a third piece, which is managing complaints. So all our companies are open to receiving complaints against them. And any individuals within the companies or individuals who have grievances against the companies from outside of the company themselves, let's say from local communities, can submit complaints to the association vis-a-vis our member companies. And then we will follow up accordingly with the companies with the interests of the victims in mind. So that comes together to demonstrate that what we're trying to achieve through the work of the association is not a gotcha. It's not, oh, well, this company is falling short of standards. Quite diverse. It's a positive dynamic that we're trying to create of working with the companies to improve the understanding of human rights, to improve the implementation of code principles, and effectively to be leaders in the industry, I dare say, from a sort of human rights compliance perspective. And that's how that fits into the human rights due diligence discussion we have today.
Thank you, Jamie. I want to turn now to Richard Gould. Richard is Global Head of Security and Market Safety at Philip Morris International. So a large multinational company, a client of private security providers. And I'd really like Richard to kind of lay the landscape of PMI, how PMI do their kind of contracting, how they're working with ICoCA, and how private security fits into the larger kind of sustainability strategy and drive at PMI. So Richard, take it away.
Thank you very much, Chris. And thanks to both of you, Jamie as well, and the Secretariat for hosting this event and for inviting us to share our experiences. To everybody out there joining remotely, wherever you are, good afternoon or good morning. I'm Richard Gould. As Chris mentioned, I'm the Global Head of Security and Market Safety at Philip Morris International. I'm also joining from Switzerland. A little bit about PMI. We are a leading global tobacco company. We operate in over 160 markets worldwide, and we have more than 80,000 employees working in over 80 countries. I'm very privileged to lead a diverse team of over 160 security, safety, and occupational health professionals, supporting PMI's transformation to a sustainable, smoke-free future. I'm well aware when you hear leading tobacco company, you may not immediately associate this with words like sustainability or transparency, but please allow me to share a bit about our story and hopefully you might reach a different conclusion. And just to give some context on our journey related to human rights and security, it's important to understand a bit about our overall transformation and our top-line commitments on sustainability. So for the last several years, PMI has been in the midst of a self-disruption. We've been reshaping our product portfolio and also our entire business around the principle of harm reduction. Our strategic approach to sustainability is pivotal to this endeavor. And to summarize in a nutshell, we seek to create long-term value while minimizing the negative externalities associated with our products, operations, and value chain. Within this sustainability strategy, we have 4 key pillars. The first is innovating for better products. The second is around operating with excellence, and this is where respect for human rights is an integral component. The third pillar is caring for the people we work with, and the fourth is protecting the environment. So our team in security and market safety, we play a key contributing role to all of these pillars, including respect for human rights in our security operations. Our work on human rights and security really began to evolve from 2017, and we were preparing for PMI's 2018 human rights commitment, which we publicly issued in line with the United Nations guiding principles. Therein, we committed to respecting human rights throughout our operations and value chain and to doing business responsibly. Security is no exception to this. And at this time, PMI also launched our responsible sourcing principles, which ensure that our human rights commitments are also embedded in our business partnerships, including with security service providers. And to deliver on our elements, the security elements within these commitments, internally, we initiated a close partnership with our sustainability and human rights teams to define what we will deliver and to begin to prioritize how to proactively address those risks. And we also identified ICoCA as the preeminent external partner with which we could engage on this journey to help us guide us through on developing the protocols we wanted to put in place, support us with training and awareness, and most importantly, ensure our commitments are taken seriously by our security service providers. As an outcome of this process, we've embedded security-related human rights expectations and deliverables into our publicly disclosed human rights roadmap. And we continue to publicly report on human rights and security as a component of PMI's integrated report, which is our most comprehensive sustainability and ESG disclosure. Now, what have we done concretely as part of our roadmap? The first step we took was to review all of our security policies against our human rights commitments and obligations. And in parallel, as we started this, we began conducting a risk mapping exercise across our entire operational footprint. As I mentioned, we have a presence in over 80 countries, and these are countries with varying institutional and legal frameworks relevant to human rights, and our operations span everything from tobacco leaf sourcing to manufacturing, research and development, supply chain, distribution, commercial activities. It's pretty extensive. And we also looked at our existing security service providers as well as our own in-house security personnel to identify what are the potential risk areas and what are the possible capability or knowledge gaps that we would need to close. As a byproduct of this exercise, we updated our security policies to embed human rights assurances into our security service provider selection process. We revised our global security policies to mandate that service providers and prioritized risk countries must be either ICoCA signatory members or, where that's not practical, must have evidence of their own human rights policies, their own internal human rights policies that we validate as being consistent with the voluntary principles on security and human rights. And we also established a due diligence process designed to identify potential human rights red flags when vetting potential security service providers. And starting in 2019, we also integrated security concerns into other due diligence processes, such as PMI's human rights impact assessment. So using a qualified third-party auditor, PMI has thus far conducted these impact assessments in Mexico, Philippines, and Russia. And while the focus isn't on security, they look more holistically at PMI's human rights implementation. In all cases, we also came away with relevant learnings, which helped us to address security-specific concerns raised in those countries. Starting from last year, 2020, which was a pretty big year in a lot of ways for those of us in the security and safety profession, we initiated the next step on this journey. We began a process to globalize our security service contracts and reduce the number of global providers from more than 30 worldwide to 2. And indeed, we're doing this for a number of reasons, including to realize financial and operational efficiencies. But one of the key drivers was also to ensure a high degree of compliance and transparency around human rights and integrity across our security value chain. As part of this process, we embedded our expectations and obligations with respect to human rights into master services agreements covering security services globally. And we've obliged our providers to commit to the responsible provision of security services, so respecting the local law, international human rights standards, and applicable humanitarian laws, to respect the UN guiding principles and exercise a due diligence process in order to identify, avoid, and mitigate risks and impacts, both in their engagements with us and as well as in their internal operations and in their business relationships. They're also committed to ensure the delivery of security services maintain in respect for cultural considerations, gender sensitivity, and personal dignity. And we have a very clear expectation that our security service providers build proper management systems to ensure all the aforementioned obligations. And this comes from hiring and training the right people, training on the principles, both the rights and the obligations, establishing and disseminating policies and trainings on the use of force and search, performing risk assessments, and of course, putting the right controls and grievance mechanisms in place. To support this, we oblige our security providers to be ICoCA members and to institute those requirements in line with ISO 18788. Internally, within my security team, we continue to focus on institutionalizing human rights practices and standards in our engagements with security providers. And we also drive this message internally through our organization through ongoing training and awareness, which includes all PMI in-house security professionals. But we're also committed to measuring and reporting progress in this space and building KPIs and metrics into our program that will help us understand what is the impact of our program, how well we are doing. And I'll give an example of that in our global security incident reporting tool, which I think probably for those of you who are in-house security professionals, most of you are capturing security incidents. We've created an incident notification system to capture potential human rights violations which may have occurred in the delivery of security operations. And those incidents are flagged to me directly as the head of our global function for immediate action. I'm very pleased to say that ICoCA has been an invaluable partner for PMI from day one in helping us shape and implement our human rights and security strategies. As we move forward, I'm very excited to continue deepening this partnership and hoping that we'll continue to engage ICoCA to help us refine our strategies, tools, standards, and training so that we can maintain our leadership in this space and also continue to support PMI's overall sustainability strategy here. But it's also about ensuring we are positioned to respond to upcoming legislation. As Jamie outlined, we can't say for sure that we're have adequately addressed all the emerging legislative topics, but I firmly believe we have the right building blocks in place to address those as they come into force. And in doing so, I expect we'll continue to minimize the negative externalities associated with our security value chain, and hopefully will contribute to positive improvements in the private security sector globally. So that's a bit about our journey and where we are and where we think we're going. I don't know, Chris, if you want to open for questions now, or we pivot to Andrew, or if you have any questions or prompts.
I am glad you brought up questions, and there are questions already coming in. I think what we'll do is we'll go through each presentation and then we'll turn to a Q&A at the end. But as people are talking, I do encourage everybody online. We can't see or hear you, but you can submit questions. Please encourage you to do that using the Q&A module rather than the chat. We have been asked as well whether people can submit questions in other languages. So we can translate in Spanish, from Spanish or French. I will not be doing the translation, however, live. I have a colleague who's going to help with that. And so if you do have a question in French or Spanish, can you make sure that you send in the question to everybody and not just me? Otherwise, you're going to test my language abilities. So I want to turn next now to Andrew Pickthorne, who is Managing Director of the Management Risk Team at Tysers, and also a co-founder of the Hostile Environment Liability Protection Program, otherwise known as HELP. And it is particularly HELP that we want to focus on. It's a very interesting story, Andrew, about why the HELP program came about and what exactly it is. But the insurance sector is absolutely a sector that ICoCA has been wanting to engage more with, along with other players in the financial services sector. But insurance companies obviously have some risk exposure to clients and private security companies themselves that they may insure. So can you tell us more about the HELP program, how it came about, why it came about, and how it really works?
Certainly will, Chris. Thank you very much for your kind introduction. And many thanks for the whole opportunity to participate in this important webinar on reducing human rights risk. Can we just pay tribute to the excellent work undertaken by ICoCA under Jamie's leadership, because it has been encouraging widespread adoption of international security standards and increasing the number of companies achieving ICoCA membership and certification, which has been really important in driving up those standards. And when considering risks, underwriters take full account of whether a client has accredited certification to those appropriate standards, whether they are members of ICoCA already, and if they have certification, and yours is viewed as the gold standard. So thank you so much for this opportunity. In the context of human rights and international humanitarian law, the roles of accredited certification to international security standards and the work of ICoCA are readily understood. So you might ask why an insurance broker has been invited on today's panel. Well, the reason is to explain the important role that insurance can play to underpin due diligence, compliance, and risk mitigation to ensure that liabilities are fully met to your clients, your employees, and third parties who might inadvertently get caught up by security operations. I'm sure that many of you will view insurance as an expensive, necessary requirement, and that's when you're being polite. And annual renewal of your policy comes around and is met with a groan. What's the amount of coverage I can get away with, the least price? Well, that's very typical, but perhaps it's not the right approach when dealing with hostile environments. By having the right insurance policies in place, with robust, comprehensive coverage, you'll be demonstrating your commitment to duty of care to your staff, your supply chain, and critically, those poor people who are caught up with the innocent bystanders. And it's a complex business. Companies and other entities operating in hostile environments face a myriad of jurisdictional, contractual, legal, compliance issues, with challenging risk profiles, all of which need to be properly addressed by your insurance policies. And despite this complexity, you need to engage in this process, because it's not just a matter for the broker or your underwriters. It's important that anybody operating in a hostile environment understands clearly their insurance arrangements in order to provide assurance to the staff, the employees, the clients, and the supply chain. In other words, you need to be discerning customers. And you also need to stress test those insurance policies once they're in place. You need to role play. You need to have desktop exercises, what if scenarios at all times, because what happens if you don't have cover for war and terrorism or political violence? What happens if you don't have use of autos covered under your liability policy? And don't forget that a road traffic accident is probably the most likely cause of accident and injury in any part of the world. What happens if you've not got failure to protect cover under your policy? What happens if you've got local subcontractors employed and they're not quite as well governed as you? So lots of questions that need to be answered every time you look at your insurance policies. Now, my colleague Simon Coe and I are very much veterans, I'm afraid, now in the field of insurance solutions for clients in hostile environments. I think I've got the lighting right, so you can't see all my grey hairs, but I've been doing this for a very long time. And Simon and I know from bitter experience what works, and we've witnessed things go catastrophically wrong. And Chris alluded to this at the beginning. In the early days in Iraq, following the military intervention in 2003, those were, of course, very challenging times for private security and risk companies, as you all sought, or they sought, to operate in a very challenging hostile environment where the rule of law was extremely fragile. And I'm referring here to the CPA, and some of you will remember that it was very fragile, the rule of law. And against this backdrop, we insurance brokers were tasked by our clients to obtain relevant and appropriate cover for companies that may have only just started, but were operating under contracts to the DoD, the DOS, and other sophisticated government buyers. And vividly, we recall the tragic events of the 16th of September 2007 in Nisor Square, when armed employees of Blackwater killed 17 Iraqi civilians. A tragedy that underscored the human rights risk of all private security operations. And in the years that followed, we were involved firsthand with the legal arguments, the court hearings, the trips to Blackwater headquarters, listening to the ebb and flow of the arguments about the governance of that company. And I'm not breaching any confidentialities here. But the consequences of Nisor Square, the earlier deaths of the 4 Blackwater contractors in Fallujah in horrific circumstances, the claims resulting from illegal export of weapons, they all led us to shape insurance products that encourage compliance, the raising of standards, and respect for human rights. Now, since those early days of Iraq, there's been a transformation, of course, in terms of regulation, standards, expectations for the sector, and companies now have a clear pathway to achieve international recognition that they are compliant, that they operate to the highest standards, and that they do respect human rights. And that pathway is to achieve accredited certification, become a certified member of ICoCA, and have robust and comprehensive insurance in place. When we are tasked with providing such insurance, our role is to encourage and advise on risk mitigation as well, to provide policies that meet your liabilities and efficiently address and settle legitimate claims, most importantly of all. So after many years of ad hoc placements, we decided to pull everything together in what Chris has introduced, the snappily named HELP, the Hostile Environment Liability Protection Program. And it's an insurance and risk management program designed to provide broad cover for all sorts of complex operations in very hostile territories. It's underwritten by a panel of Lloyds syndicates, which have been writing specialist risk operations for many years now across the world. And they've got a lot of expertise and experience in underwriting these risks. And we've maintained our private security and risk management core base of clients, but we've also expanded now into the construction and extractive industries, intelligence providers, logistics firms, NGOs, charities, and the like, all of whom operate in common in hostile environments. At the core of the program is liability insurance, but it also includes personal accident and kidnap and ransom insurance, very importantly. And we were determined at the outset of launching HELP that it should be a tool to assist in raising standards, for the sector. So we took the decision to make the help products available to all brokers, all Lloyds brokers, so with no attempt at exclusivity. Any Lloyds broker then can access the help products, and companies just simply have to request their broker to research what help can mean. Potential clients complete an application form, which captures all the standard information, the revenue and wage roll, the activities of the firm, etc. But it also refers to the UN Global Compact, the guiding principles on human rights, the voluntary principles, and of course the Modern Slavery Act. So it takes more than a passing nod to these important aspects. And it's more than just insurance. I said it's a risk mitigation tool. It provides policyholders with access to a great range of risk mitigation services. It gives 24/7 crisis guidance, and it benefits from strategic observations and insight, thought leadership, if you like. Now, risk mitigation is really important because it's the same thing as saying risk improvement. And that really means that everybody's a winner. A policyholder is supposed to act as though they are uninsured at all times. With risk mitigation and risk improvement contributed to by the insurer, everybody wins. The risk is improved and removes risk to the balance sheet. And as an obvious risk mitigant, policyholders can request a contribution from the insurers towards the cost of certification. Now, clearly, underwriters prefer companies that are already compliant, that respect human rights and international humanitarian law, and have reached accredited certification. But as part of the underwriting process, they look to see whether you've reached PSC 1 or ISO 18788, and if not, they will provide a pathway to achieve that certification, and they will contribute towards the costs of certification. The overall aim is to improve risk profile. And as you'll be aware, or may be aware, there are currently 3 UCAS accredited certification bodies. We work with all of them and help policyholders have the opportunity to procure their services with a contribution to their fees paid by the insurer. And you'll be aware that the certification cycle lasts for 3 years, which is good news from the insurer's point of view, because it means that they're not just getting a snapshot in time, they're getting constant surveillance and constant updates on the conformity of that company. And the same recognition applies to the 3 certification bodies accredited under the International Accreditation Forum, the IAF. And of course, the help panel underwriters are very aware and agree with the ICoCA board's stance on trying to explore additional pathways to certification. And if it's not a contribution to the cost of certification, underwriters would also consider making a contribution to the cost of ICoCA membership, full stop, whether you are early stage or fully certified member of ICoCA. And one other really useful benefit of a help policy to mention is this crisis guidance, possibly the most important of them all, because it is 24/7 and it's real time. In the event of a crisis, the phone rings and instant advice on how to deal with an incident is very, very important. And we've had many incidents now of things like wrongful, unlawful detention being sorted out very quickly before a situation can become really ugly. So just to sum up then, help is available to all Lloyds brokers. It's designed to be broad and robust to cover all liabilities that may occur in operations in hostile environments. Help actively supports the excellent work done by ICoCA, and it encourages membership of that body. They differentiate between affiliate, transitional and certified membership. And as I repeat, ICoCA certification is recognized as the gold standard by insurers. And appropriate comprehensive insurance plays a key role in raising standards for the private risk and security sector. It gives confidence to the clients of those companies and has moved a very long way since the earlier frontier Wild West days that I described earlier. So that's me, Chris, and ready for any questions. Thank you.
Thank you so much, Andrew. And we do have lots of questions coming in, so thank you. Keep sending them in. We'll get through as many as we can. The first, I want to kind of group a few together. So Joan Fontaine mentions that fundamentally supply chain responsibility should be shared by all participants in the supply chain. If the supply chain is particularly long, how would you mitigate human rights risks throughout that chain? And this again relates to a question by Rebecca de Winter-Schwitt, which is specific to Richard. She asks, what are the potential second order effects of reducing your global security providers from 30 to 2? So who lost their contracts with Philip Morris, potentially smaller companies in the global south? And do your 2 security providers subcontract out to local providers? If so, doesn't that shift the compliance burden for the activities of subcontractors to the 2 providers away from PMI? So a question about subcontracting there, which we know is kind of prevalent throughout the industry.
Yeah, absolutely. I'll start with that first bit in terms of how we've structured our service agreements with our global providers. And I think you can use the phrase subcontracting. The way we look at it is really actually as a global account management model. So we have 2 large providers who are well-established international players, ICoCA members, and have committed to us on a number of human rights components. They do indeed manage some local providers in a number of countries, not all, but in a number of countries that is indeed the case. And exactly the same rights, obligations, and expectations that we cascade to our direct providers are embedded in those relationships as well. Also, in terms of how we've structured those agreements, it's not the case only that we're hands off from our relationships with those providers. I mean, indeed, we can't possibly be, because by definition, they're working in our sites, in our premises, on our operations. So there is no hands off relationship there, and we've structured those agreements such that we do have legal agreements with global providers, and we have legal agreements in place as well with their local providers with whom they're managing the account on our behalf. So that's more of a commercial relationship, but in terms of liability, I would say the liability is essentially the same. So precisely the same obligations and the same requirements are cascaded at all levels of our security value chain through this model. In terms of who potentially lost contracts, of course, there are companies that lost contracts with whom we've had a relationship. I don't think it would be accurate to characterize that as only companies in the global south at all. I mean, we enjoyed relationships and partnerships with providers of various sizes in different parts of the world. So in some cases, we were able to retain those relationships, and in others not. But I think that's a normal part of going through a global sourcing exercise like this, and a relatively common exercise. But I wouldn't say that there's been any kind of disproportionate impact in any part of the world.
Thanks so much. I want to turn to a question from David Eisenberg, and Richard, again, I'll turn to you and maybe then kind of Jamie afterwards. So David mentioned, he asks, with regard to the mandatory provision that clients must hire private security, do contracts also include provisions mandating the hiring of oversight personnel to monitor their conduct and mandate budgeting for the same? And I just want to kind of expand on that last point about budgeting, because what we are aware of is that there is very much a race to the bottom going on across the industry. And that's really being driven by clients who are basing their contracting decisions solely on cost. So they are hiring the cheapest providers. That has consequences, because we know that, you know, if your budget doesn't provide for decent salaries, the guards are not going to get paid salaries. Guards are working 12-hour shifts, 6-7 days a week, not being paid late. I'm not mentioning, this isn't your guards, this is just, you know, generally across the industry. So can you talk a little bit about, you know, David's question, and more broadly, you know, this issue of cost, how does that play out for PMI?
Look, certainly when we looked at this global model, cost was a consideration, but I can say absolutely it was not the case that cost was the only consideration. Of course, when you're making a business decision, you have to look at the cost impacts, and we believe actually that we'll achieve some cost productivities through this model, but those will largely be realized through, I would say, operational efficiencies as opposed to taking out margin or taking out wages. In fact, we structured this engagement to make sure that we have transparency around actually what is the take-home wage of a guard in a given country. Because I'm well aware as a buyer of security services that this is an area in which security providers sometimes obfuscate a little bit, and they'll pad their margin with their overhead, or they won't fully disclose what the wage payments are and what's the take-home pay of a given guard. We went country by country in this exercise across the entire world, actually, to understand what is the take-home pay of a security guard at a different job profiles, whether that person is a site security manager or that person is a you know, in a more junior position. So in that sense, we ensured full transparency throughout this process. And I think if, you know, whether you're looking at local contracting or global contracting, you absolutely have to do this, because otherwise, as you said, Chris, you don't have that level of assurance that the guards are being paid a fair wage, and that it's not being captured by the provider. I think any of us who have experience in security contracting these types of services knows that this is potentially a watch out area. And if you're working with potential bidders who won't disclose that information to you, I would already consider that a red flag in a kind of pre-qualification round. So that's very important to us. And as far as oversight, and again, I think that's an advantage that we will get with this model that we're pursuing, which is a layer of account management as a service coming from our providers. So we're actually expecting that there are personnel dedicated to ensuring compliance with our requirements and to, you know, executing and ensuring you know, consistent delivery against the KPIs, some of which are related to the delivery of human rights. So you know, indeed, I think that's kind of built into the model. And that's one of the advantages that you actually can get with this kind of model. Not to say it's not without risks of its own, but one of the advantages you can get is actually building that management layer that gives you a little bit more transparency and the ability to kind of you know, visualize this on a global level, as opposed to relying on relationships, you know, country to country basis, where you have you know, very different standards of delivery. So that, I think, is actually, you know, one of the key structural advantages that we've tried to go after here. Hopefully that answers the questions a little bit.
Yeah, no, thank you. And Jamie, turning to you, can you just, you know, say a few words on what the implications for human rights particularly are when decisions are based solely on cost alone?
Yeah, thanks, Chris. So before maybe turning to that, just maybe to regroup and also David and Joan's questions there on the supply chain piece and the verification component. I think on the supply chain piece, if you look at where jurisprudence is, I think, taking the debate, the discussion of a sort of diffused, diluted supply chain, which is too long in terms of responsibilities, is a weaker argument today than it was a few years ago. It's clear that every single component in that supply chain is going to have a clear responsibility. And it's been difficult for parent companies to escape any form of liability if they don't fulfill their overall responsibility throughout the supply chain with their providers. And specifically, when we're looking at the code, companies that join the association have not only their own direct responsibilities, that they have to cover. But they also need to make sure that when they contract with any subcontractors, that those subcontractors are also compliant with the code. And security providers that are members of the association or affiliates cannot take contracts with clients where there's a risk of a potential non-compliance issue with the code as well. So the security companies have this sort of their own responsibility downstream to subcontractors and upstream vis-a-vis their clients. The oversight piece and the cost linked to oversight, what we have seen with some clients, some multinationals, is that they are looking to engage a long-term relationship with their security providers. So not just a 6-month contract, it could be a multi-year kind of contract. So they want to build that relationship, the trust, the capacity of the security provider. And I think in some ways, PMI Richard have mentioned what they've been trying to do. Now, we've seen some clients looking to contribute to, let's say, cost of membership or supporting security companies as part of the certification process, especially for local security providers. So it creates that additional incentive within the contract to say, if we give you the contract, we'll support you vis-a-vis membership with the association and or certification processes, a bit like the help product that was referred to earlier. And in terms of the cost piece, much of the focus has been on multinational, let's say the business entities. But we can look at any number of sectors out there. We've recently been working on issues linked to humanitarian agencies. It's clear where there's a limited budget being associated to the provision of security and the contracts linked to security, the knock-on effect vis-a-vis potential human rights risks is evident, whether it's from work conditions, shifts, lack of training, lack of, let's say, proper staff being brought on board, high turnover. There's a number of issues there which, by virtue of the fact that the contracts are badly paid, can create a greater risk for human rights abuses in certain contexts. Whereas a well-trained, well-staffed, and well-financed security company, I think, has a better chance of being much more compliant with human rights obligations.
Thanks. Now, I want to group another kind of couple of questions together. We've had a couple of questions based on kind of regional issues. And so Colonel Andre Viana in Sao Paulo wants to know how this works. And he's talking about the kind of PMI model in Brazil and Latin America. But I want to turn to connected with that, a question from Graham Small. I'm not sure which company Graham is with, but he says, as a company, we want to make ICoCA membership mandatory for all our private security subcontractors. This is easily achievable in countries like Iraq with a well-established private security market, but far more challenging in other countries with less well-established private security market. What can the ICoCA do to assist commercial entities like ours achieve this goal? And again, I turn to Richard and Jamie because, Richard, I think clients definitely have a role to play in this in driving the market. Yeah.
So on the latter point, I can take an example, and this predates what I've outlined in my remarks about a global contract, and I can recall very specifically an engagement with the service provider in the Philippines. He's our existing service provider. And when we made the decision to require ICoCA certification for certain high-risk countries, Philippines was indeed one of those high-risk countries that we had identified. And this was really a partnership discussion that we had with our existing provider in the Philippines, both encouraging them and I think expressing clearly that if they wanted to retain our business, this was a must, but also trying to explain what was the potential value add to them. And in fact, they became, I think at the time anyway, I don't know if this holds true now, but they became the first ICoCA certified security service provider in the Philippines. And they eventually viewed this as a potential value add and a potential marketing tool for them. Because then they could go to other potential clients and say, look, this is what we've committed to with PMI. We're now ICoCA certified, because they were anticipating the market trend as well, that they would potentially have other clients, either because of the client company commitments or indeed because of legislative obligations in different parts of the world that would be requiring this. And to me, it's not totally different from any discussion of global standards. And to pick up on the question in Brazil, frankly, I've heard this a lot in my career in many different parts of the world, that certain global standards just can't apply here because the cultural considerations are different, the political considerations are different. But nevertheless, I've seen time and time again that if you have the right conversations and you bring the right stakeholders to the table, and you can convince a business partner of the value add to them, and in particular, the potential commercial opportunity that will come from enhancing their value proposition to other clients, then the conversation starts to shift a little bit. And we've had this experience with, for example, supply chain security standards with TAPA. I can't tell you the amount of times I've heard in different parts of the world that it can't work here because this country is different. It can't work here because this country is different. And lo and behold, eventually it does work. So it takes time, it takes some patience, and I think it takes framing the conversation correctly with those partners if you want to bring them aboard on your journey towards human rights compliance and security. There's obviously companies that are not going to be willing to engage in that, and maybe this is not 100% foolproof proposition that I've outlined here, but I think by and large, if you put in the legwork and make it an attractive proposition to the security service providers, they may actually see the benefit. And indeed, it is a fact, and it's evidenced by what I'm presenting today, that there are large multinational customers looking for security service providers that meet these requirements. That's a fact. So if you're able to compete with that as a value proposition to a customer, it positions you with an advantage.
Jamie,
If I may just step in, yeah, definitely, Chris. I mean, I think on the piece there with regard to those environments where there's a, let's say, less mature market or less regulated security industry, what we clearly identified as one of the major challenges for many of these local security providers was the question linked to certification. That's the gold standard, but the reality check was that achieving certification, accessing certification bodies, affording certification processes, especially if they had to use international certification bodies, was simply out of reach for many of the local security providers. So, but that, and there was also, I think, a question mark that many local security providers had. It was literally they wondered whether or not they could even reach the standards expected of them under International Code of Conduct. The understanding, the awareness, the issues that the code developed, it seemed so far out of reach for many of these local security providers. So a couple of years ago, we developed a new category of companies that could become part of the certification, affiliate companies, in particular with these local security providers in the less mature environments, but complex and high risk environments, where international clients and others were relying on local security companies for their offering. And by coming on board as affiliates, it's part of the initial education building process with those companies. It's giving those security providers the confidence and understanding of what is required to implement the International Code of Conduct. And then when they reach the stage through monitoring and support by the association to go down that certification pathway, they're in a much better position to actually understand what is expected of them. And I dare say to do the job a lot better in terms of culture and leadership. So I think it's approaching each context on a case-by-case basis, but it's also recognizing that the capacity of some certain companies will certainly not be matched by the capacity of other large international companies.
Yeah, I think, Jamie, you hit right on it. I mean, capacity building or capability building, it doesn't need to be something that occurs overnight. It doesn't need to be something where, you expect a provider, if you're committed to working with a provider, where you expect them overnight to be fully certified and able to implement every line item to meet your requirements. I mean, I think there's an element as well for the client to be able to support in terms of capability building and setting clear milestones as well. If we expect to establish some of the key elements, let's say, without achieving certification in year one, that can at least be a roadmap for the supplier to start making concrete steps, and that's something we can implement over time with some specific objectives in mind. And again, I don't think that's really too different in this context as it would be in any other business partnership where you're working to implement a standard with a commercial partner.
Well, listen, I want to thank all the panelists. We unfortunately have run out of time. There are many questions that we haven't been able to get to. What I would say is that we want to engage with the market, with clients. It's great to be engaging with the insurance industry as also a driver in this. If you do have more questions for either ICoCA or any of the panelists, I encourage you to please send us an email. You should see the email address up there on your screen. So that's secretariat@icoca.ch. We want to thank Richard, Andrew, of course, Jamie. And these organizations we believe are playing leadership roles in really bringing the market up and bringing standards up. That can only happen if more clients step up and take a leadership role in these issues too. And so I encourage you all to engage with us on this journey. But for today, I want to thank you all. Bye-bye.
Thank you.
Thank you.